Really very pleased and honored to be here. A few years back when I was at the place up the road, I would come to the ISG meetings faithfully, and I really felt that I learned a great deal from what was going on here. And so it's a great pleasure and a privilege for me to be on the other side talking to you. What I want to talk to you, of course, I'm a law prof, so what I want to talk to you about is something in the area of law, but I think it really is also in the areas of politics, religion, and society. And it's in respect to various changes, I shouldn't say that, actually, legislative modifications of the law of marriage and divorce in Iran. This is something that the situation of women in Iran has been written about a lot in English. My feeling is that it's often from, what shall I call it, a position in which the empathetic writers identify with, not generally with women in Iran, but with women in Iran, in particular, very situated kinds of locations. So that one hears a good deal about the situation of women like the writer. And often that is an upper-class, educated woman who herself or her family before the revolution were in a fairly good situation, and the women in her family were in fairly good situations as well. And for many of those women, the revolution did not, in fact, improve their condition at all. In fact, for many of those women, their situation became worse. What I've found interesting is the extent to which that isn't true when one speaks more broadly about the situation of women in Iran. And in order to talk about that just a little bit, let me tell you how I got interested in this. I got interested in this really because I was interested in women in Turkey. And I had a sort of polemical kind of position about women in Turkey, which was to the effect that women in Turkey, essentially because of the secular state, were in better shape than women in the Middle East and North Africa generally. And of course, here when we talk about the Middle East and North Africa, we obviously know that that's an ironic term almost. Neither Turkey nor Iran are really the Middle East and North Africa. But this is the kind of language that we tend to use about when we're talking generally about Muslim countries. We say Middle East and North Africa. Anyway, so I'm investigating Turkey and the condition of women in Turkey and making this argument that women are better off in a secular situation. And I start getting comparative data. And what I found, and it was very interesting to me, was that in fact the situation of women in Turkey was almost parallel to the situation of women in Iran. And that really obviously shot holes in my argument. And I had to rethink things. And it really made me wonder, because I had not read much about women in Iran that indicated there had been any improvement in the situation of women in Iran post the revolution. But the data, and that's sort of what I have on my computer, and we can talk about it later if you want, seems to indicate fairly clearly that at least in large-scale social measures of women's progress and advancement, things like literacy, education, labor force participation, political participation, reproductive control, the situation of women in Iran has improved markedly since 1980. But when you say that, of course, you're going up against another reality, and that's the reality that with the inception of the Islamic Revolution, the legal political regime changed substantially. And to a large extent, that legal change, at least, was felt most directly by women, because what had previously been a law, and here I want to focus in particular on the law of marriage and divorce. I know there are other aspects of law that that are gendered and that touch upon women's situation, but I want to talk about the law of marriage and divorce, partly because I think that that's where the sort of heaviest impact of the law is on women, that where it's most likely that women are going to come in contact with the legal regime. We know that the legal regime prior to the Islamic Revolution, the law that governed marriage and family, was a law that had been created by the Shah's government, called the Family Protection Law. And the Family Protection Law, which was initially passed in 1967 and then amended in 1975, made significant modifications in the traditional law of marriage and divorce in ways that were beneficial to women. That is, the unilateral power of divorce, which a religious authority granted to the husband, was constrained. It was not entirely eliminated, but it was constrained in the sense that a divorce could not take place without a judge's approval. Prior to that, all that had to happen for a divorce to be legal was for it to be registered. Now the judge had to approve of it. And the judge had to approve, essentially, of the situation in which the woman would be left post the divorce, and approve of whatever kinds of custody arrangements that were made for the children. And traditionally, of course, the custody of children would go directly to the father or the father's family. There were also grounds created for a woman to initiate divorce proceedings, and amongst those would be the husband's a restriction on the husband's right to a polygamous marriage. None of this was done in flagrant contradiction of religious law. The clergy under the Shah was, at least one important section of the clergy under the Shah was fairly compliant, and was able to be kind of browbeaten into accepting the family protection law and saying that it was compatible with Islam. And essentially these kinds of modifications, which were to the benefit of women, were achieved more procedurally than substantively in terms of the kind of change that was made in the law. So that's the condition of the law of marriage and divorce at the point at which the revolution takes place. Revolution takes place in by early 79, the Shah is gone. Khomeini returns to Iran. Within 2 weeks of his return, that is, practically the moment he gets back, he declares the family protection law un-Islamic. Says that it's abrogated. Says that anybody who has gotten divorced under this law and remarried is an adulterer, that the divorce is no good. So it's obviously high on the agenda of religious figures to get rid of this kind of what appears to them as secularization of the law of marriage and divorce. But what's very interesting and almost unbelievable, really, is that within about 15 years, that law, the law of marriage and divorce of the Islamic Republic, is essentially the family protection law itself. A little bit modified and even a little bit better. How is that possible? Here's this law that's un-Islamic and that in 2 weeks is scratched off the books, and yet reappears and in fact is amended in ways that makes it even more positive for women. I want to talk to you and focus on two particular changes that I think are very interesting and try to interlace that with what I think is the reason for this larger question. Let me tell you about the two particular changes that I'm interested in. These are two amendments to the law of marriage and divorce that take place, that become effective in 93 and 96. They both have to do with the situation of the woman post-divorce. Now, it's interesting to me, as I say, that these two changes take place in 93 and 96. Let's have a little Socratic dialogue here. What would you say would be the significance of something that passed of changes in the law of marriage and divorce favorable to women that take place in 96? Anybody? Does a ring a bell for anybody? 97. But you're exactly right. That's exactly the point that I want to make. These take place before reform, before 97. 97, of course, is the year Khatami is elected with a stunning 80% of the women's vote. And it's sort of suggested that Khatami represents reform. My thinking is that, in a sense, it's reform that makes Khatami possible, rather than Khatami making reform possible. And I think that these two laws are kind of indications of that. So what are these laws? To talk about the laws, let me just then go back a little bit further and just talk about what the sort of classic situation of marriage is. Classic situation of marriage is that it's a contract between a man and a woman. It is a gendered contract in the sense that both parties don't have the same obligations. The woman's obligation is to give her obedience and sexual reproductive services, in return for which she's entitled to support for the rest of her life. That support takes two forms. Her daily maintenance while her husband lives and while the marriage continues, and a promise that should the marriage end either by his death or by his divorcing her, she'll still be supported, essentially at the same level at which she expected to be supported when she entered into the marriage. So that means that the husband has two obligations. One is this daily maintenance, and the other is to, in effect, endow her with a capital sum that's sufficient to support her should either of these two catastrophes, death or divorce, take place. That second obligation is reflected in the marriage gift, the mar, which is supposed to be a capital sum capable of supporting her should she need it. But that's it. So that upon divorce, she has no other call upon him other than that marriage gift. Generally speaking, as you know, the marriage gift, although it is owed to the wife, is not requested by her at the time of the marriage. It remains a debt or a charge upon him. So that at the point at which the marriage ends, it's either a charge upon his estate, and it's a charge that takes precedence over all other creditors, including heirs, or at the divorce, he's got to pay it to her to make sure that she can be supported. So, there's no such thing as alimony. There's no other obligation he has. He has an obligation to the children, obviously, but he has no obligation to her. The problem for, if one is going to restore the classical law of marriage and divorce in a modern situation with these marriage gifts, particularly in Iran in the 80s and the early 90s, is that there's a tremendous inflation that's going on, sometimes as much as 25% a year. And when you start piling the 25% on the 25%, after a certain point, this marriage gift is basically worthless. So you put back in place the classical law of marriage and divorce without a judge having to okay the arrangements that exist upon the divorce. And the wife of many years can find herself absolutely without support at all, on the street, in effect, with nothing to provide for her. Now, that's a sad story, but it's what would happen, or would have happened, had the law not been modified. And it was modified. And the question that's kind of interesting is, well, why was it modified? So the question I ask is, well, why was it modified? And it's modified, I think it's obvious why something like that is modified, and that's because there's a demand for it to be modified. That is, it's an intolerable situation for women that upon divorce they should find themselves penniless and without any support except that which is offered by the kindness of a family. And the reason that but what was sort of more interesting, or I think more interesting, is the reason that demand is, or that need is met, is essentially, I think, because the political situation is such that the support of women has become not just salient, but important. And that seems odd to talk about in terms of the Islamic Revolution, or at least the general American notion of the Islamic Revolution as being anti-women. In fact, of course, the revolution drew a great deal of support from women, and that support that it got from women was evoked by religious figures. That is, important religious figures, up to and including Khomeini, said that women were it had a responsibility to be politically active. And that was a tremendous change from what anybody had ever heard of before from religious figures. Those of you who are familiar with the history of the Constitutional Revolution back at the turn of the century know that there was a great deal of arguing and difference over whether women could play any role at all, and most significant figures agreed that they should not, though some brave people did argue that women should be politically active. But there had never been a point, really, at which religious figures evoked the agency of women. But that did happen in the course of the revolution. And what's so very interesting about that, of course, is that Khomeini had gone publicly into opposition to the Shah. His first public opposition to the Shah was around what issue? Votes for women, which he denounced as un-Islamic, and said that that the Shah's proposal to do this made him on a par with the killers of Hussein and Hassan. I mean, it really, the most powerful rhetoric of Khomeini that he had yet used was around this issue in 1963. So obviously people thought that when Khomeini came back, it would not be good for women. But instead, Khomeini, both from Paris and on his return, asked women to be politically active and to continue to be politically active, finally winding up by saying not only that women had the right to vote, but giving a fatwa that it was their divine duty to vote, that they owed God the vote. Why did he do that? Why do you think he would have done that, change that position from 63 to 79 and 80? Yeah, women were going to support him. I mean, it's quite clear, and this is true, I think, not only in the context of the revolution itself. That is the revolution. Valentin Mogadam talks about there being two revolutions. One is the revolution that gets rid of the Shah. The other is once the Shah is gone, who's going to run the state? And there are a lot of people contending, because the opposition to the Shah has been extremely broad. By the time the Shah goes, there's very few people left who have any, sort of very kind of thin layer of people who profited from him, who have any affection for the Shah. Everybody's against the Shah. So it's not clear who of everybody who's against the Shah is going to take over the government. And there are a variety of active political forces and forms, a secular liberal groups, secular left groups, religious left groups, et cetera, who are all contending for power. And what Khomeini does, in effect, is to mobilize a group that's previously been unmobilized, but whose support is very much worth having, i.e. women. So that women become, for the Islamic government, a constituency, a group whose active participation is necessary. And that only goes on being true in the context, it becomes even truer in the context of the Iran-Iraq War, which develops very quickly thereafter, and in which hundreds of thousands of men are mobilized, which means that the women who are left behind are by necessity take more active roles in supporting their families and also in supporting the men who are at the front. So that women who have previously essentially not been able to, even if they wanted to, be active, are told that they must be active, and that if their husbands don't want them to, they should tell their husbands it's for God that they have to go out and be ambulance drivers, or et cetera, whatever the requirements are. So that the importance of women to that coalition which is running to the group which is running the government does not diminish once they succeed in triumphing over their enemies to the left and to the right, but only increases. And Khomeini at various points steps in to make changes, modifications in traditional practices which are to the benefit of women. So that, for example, the state provides payments to the families of martyrs. One of the things that this does, I mean, one hates to see this kind of greed, but I suppose it happens everywhere. It makes the children of the martyrs kind of worth something, and so various kinds of greedy grandparents come out of the closet to take the children away from the widowed mother, because they can get the payments to children of the martyrs. So this means here's the woman who's lost her husband who now suddenly loses her children as well, which is a tragedy, obviously, a double tragedy for her. The women's press, which has not, by the way, been silenced, but has been Islamized, takes up this issue. And the consequence is that Khomeini steps in and says, yes, it's true that upon the death of the father's parents are, in fact, the children's guardians, but they're not necessarily the children's custodians. That is, physical custody can remain with the mother, although the parents, the paternal grandparents are the legal guardians. And of course, the person who has custody of the children needs the money to raise them, so she keeps the money. And this is something which Khomeini personally intervenes to do. Another thing he intervenes to do is to put in the marriage contract a provision around this issue that I've been talking about, that is the issue of how the wife is supported upon divorce. And he puts in the marriage contract a provision that says that upon dissolution of the marriage, half of the property in the marriage acquired during the marriage should be the wife's. Again, this is not required by religious law, but he says it's not un-Islamic. Now, this is in the form marriage contract. In practice, apparently, it is not much relied upon. Ziba Mir Hosseini tells us that during the year she spent attending divorce court in Tehran, she never heard any claim made for that half. So it apparently does not really solve the problem of supporting the woman who is divorced. And that's the problem that, as I say, confronts the parliament in the early 90s. The war is over. My point about the war is that it has further mobilized women into public life and into political life, into the labor force, into social activism. And they are not prepared to continue in the situation where there is no guarantee of this support. So the parliament takes a couple of different stabs at solving the problem of support for women. One of the problems with Khomeini's modification, half the property of the marriage goes to the wife, is that it only works with marriages that are contracted once the new provision is put in. In other words, it's a new provision in the form contract, but all the old form contracts don't contain it. So it doesn't, in fact, help the wife. So one of the things that you would want from a new provision would be that it would cover women who were married before the new contract went into effect. The first attempt doesn't really do that, but it's still worth talking about because it represents a very interesting rationalization of legislative modification with religious law. The contractual notion is she's entitled to maintenance because she gives her obedience and her reproductive and sexual services. But in fact, of course, when a husband and wife are married and are in the same household, she's providing lots more, generally speaking. Generally speaking, she's taking care of the kids, she's keeping house, she's doing all that uncompensated labor that everywhere around the world is generally done by women. And the argument is made that although this labor this labor should be compensated for at the point at which the marriage dissolves. That is, the fact that she's doing it voluntarily doesn't mean that she shouldn't be compensated for it. And that makes sense, of course, because people work voluntarily, as long as they're not slaves, and they're paid for their work. And this clearly is work as well. So the argument is made that in the religious account of human transactions, it's held to be the case that nobody should labor without compensation. Anybody who enters into an arrangement to do work should be compensated for that work, leaving aside the question of slavery. Free persons, at least, those who freely exercise their will to enter the transaction should be compensated for it. And that becomes the basis for a piece of legislation which provides essentially wages for housework upon divorce. And let me say that that is an argument that has yet to succeed here. In fact, there's lots of trees been cut down writing law review articles by feminist lawyers about wages for housework upon divorce. This is a provision that is put into the divorce into the contract in '92 by the Majlis, rejected by the Council of Guardians, but eventually makes its way through the Expediency Council, meaning that religious authorities agree that this is not un-Islamic. There's some reasons why it's not fully satisfactory. For example, there's some hedging about whether if this is the tradition of her community, maybe she shouldn't be awarded that money. And since you can kind of make an argument that traditionally she was never paid wages for housework, that it's the tradition of everybody's community. And it's not clear to me to what extent that caveat has been enforced by courts. I know women are getting wages for housework, but how widespread the refusal to give it on the basis of traditions of community is, I don't know. But it is in the law. The other change, which I think in a sense is the sensible one, but the one that was the most difficult to achieve, was, and here the Majlis just had to bite the bullet, but did so, and that was that they inflation indexed the marriage gift. So that whatever the amount of gold was that the marriage gift would buy at the time that the marriage was contracted remains the sum of the marriage gift. It doesn't matter what currency amount was denominated at the time. The actual value of gold at the Central Bank of Iran is going to be the way in which you decide how much the marriage gift is worth. And that gets around the problem of inflation, and it gets around the problem of a new term being imported into the marriage contract. Every contract will contain a marriage gift. Hopefully, most of them will be actually in for some amount of money. And I would put the footnote here that in the 70s there was a tradition of making the marriage gift something romantic, like 3 roses and a lark or something like that, which obviously is not going to give you much support at the time of your divorce. But once people woke up to the fact that it should be currency denominated, it's going to the 96 law makes that inflation indexing mean that the marriage gift retains its value. And obviously there was a good deal of opposition to this proposition, that it was going to diminish the warm sphere of family life, that it was going to threaten, the more interesting argument to me was it was going to threaten all contracts. In other words, that there was going to be an argument for extending the inflation indexing to any contract that anybody entered into, thereby disrupting commercial transactions. But that, of course, didn't happen. But amongst the arguments in support of it, there's some interesting language that's used in the Majlis. I'll find it here. Yeah, among the reasons that, and look, by the way, what's happened here, which I think is very interesting. When you say the marriage gift is going to be inflation indexed, you're in fact taking a contract that's written between two parties. It's a private contract between the two parties, and saying that the state has enough of an interest in it to imply something in the contract that wasn't written in by the parties. In other words, it's no longer just the will of the two parties, but it's also an additional kind of social interest represented by this legislation, by the Majlis. There's a social interest in this contract that's sufficient to allow the state to put something into the contract. And what the state is putting into the contract is the amount of currency is going to be inflation indexed. It doesn't. The currency denomination is actually going to be gold. So the points that are being made in the Majlis as to why it is all right for the Parliament to, in effect, intervene in a contract between two parties are things like, here's the kind of language that we find in the Majlis debates. It would be socially unjust not to imply this term in the contract. Again, meaning that there is a social interest in marriage that goes beyond the will of the parties to the marriage. That these terms can be implied because in Islamic jurisprudence, in fact, time and place are important. So that the kinds of rules that might have applied to marriage in the past are not violated by having new rules today, because the social situation of the marriage today is different than the social situation of the marriage of yesteryear. That today religion is not understood to leave management of a divorce entirely in the hands of a male spouse. So that despite the fact that we have the unilateral power of divorce in the hands of the husband, there's a social interest that allows that to be cabined and constrained to some extent. And finally, that these kinds of provisions protect the family rather than diminish it. So that all now I'm not saying that this passed without opposition. There was a good deal of opposition, but it did pass fairly convincingly. And again, it did not pass the Council of Guardians, but it did pass the Expediency Council, indicating that there is thought to be a social interest in maintaining, or in I don't know if I want to say maintain or create, but at least in having more assurance, a kind of social safety net for women in the case of the unilateral power of divorce being exercised by the husband. And that is sufficient, that social interest is enough to support these modifications and additions to the traditional law of marriage and divorce. And again, I suggest that indicates the extent to which women are seen as a constituency that needs to be satisfied. Now, obviously, I don't think that means that Iran is free of a variety of other kinds of laws that are difficult and that may make life difficult for women. And there's all kinds of ridiculous little stuff. You can't put a woman's picture on the cover of a magazine, for example, or these medieval kind of punishments for sexual deviation by women, which are suspended at this point, but of course every so often you find some nut judge who's willing to impose them. But those are, what shall I put it, I think I would call those rights issues. They're not issues that are of interest, or of consuming interest at least, to the mass of women. The mass of women, divorce and family law is very important. Who gets custody of the kids is very important. Do I have enough to support myself is very important. And that's the kind of thing that can't really be enforced if you expect women to continue to support you. And in that respect, the Islamic Republic is prepared to integrate modifications of what has traditionally been understood as the law of marriage and divorce. And those modifications, as I pointed out before, are prior to the reform movement and have continued post the reform movement. That is, there has not been a move on the part of the Ahmadiyya government by any means to change those, though there has been change of various other sorts of, for example, what Khatami had as the Office of Women's Political Participation now becomes the Office of Women and the Family. But there's still an Office of Women, and that was something that only emerged in the 90s. Prior to that, in the decade of the 80s, in the revolutionary period, it was thought that whatever the problems of women were sort of epiphenomena of not having a religious government, and as soon as you had a religious government, those problems would disappear. It became clear that women, in fact, in the 90s, it became clear that women had to be attended to as women, and that simply having a religious government wasn't going to solve those problems. That insight remains, and I think that is an interesting characteristic of the Islamic Republic, and one that we don't really pay enough attention to. So let me, I think I've talked long enough. Let me stop here and see if you have questions, and I would be happy to try to answer them. So, yes, sir. Thank you. Let's do questions now.
when, all of the marriage and divorce law, that says the judge or someone under some condition can overrule this law?
Well, child custody is a place where, at this point, you have something that's essentially a best interest of the child standard. So the understanding is that you should, generally speaking, follow Islamic law if you can, and the father is the guardian or the father's family. But there's also a best interest of the child is a kind of term that's used in the U.S. as the basis for decision making on where the child's custody goes. And what's said there is if it's the case that the father or the father's family are not fit to raise the child, then the custody can go to the mother. So that would be an example of where a judge can step in and do something different. I think there's probably other examples, but that's at least one. Is that helpful? By the way, I want to really stress that I use the term modification instead of change, because we understand that the law is Sharia. Sharia is divine law. It's unchangeable. But there's a whole bunch of ways in which the interpretation, the jurisprudence of Sharia, the fiqh, can in fact be interpreted in different sorts of ways. So you never say, oh, look, we're changing Sharia. You always say, there's a modification that's based on time and place, so there's a modification that's based on a contractual understanding or whatever. And that's essentially what's going on in all of these situations. It's not change, it's modification that stays within the bounds of what's recognized as jurisprudential interpretation. Yes, sir.
There is a law, very ancient law, that limits both sects of Islam, that if the woman gives up the money that are actually given to her as a gift at the beginning of the marriage, she would have the right to divorce. It's not unilateral law. And so this is practiced in some countries and also by some Shiite interpreters. So why do you think that this law has never been implemented in the societies, like in individual societies?
I'm not quite understanding. You're saying that if she doesn't get her marriage gift?
No, for example, if she has got a marriage gift, if she returns that marriage gift,
Yes.
she can get divorced without the husband's.
Yes. No, that's actually that's a good point, and I should have talked about that a little bit. Part of what inflation indexing the MAR does is give women a leverage against divorce as well, or give them a leverage to get a divorce themselves, because or to get custody of the kids themselves. So just as an example, if he wants to divorce her and she demands the marriage gift, he may find it very difficult to come up with that capital sum. So she can negotiate with him to get custody of the kids. But the other thing she could also say to him is, I want a divorce, and if I get the divorce, or if you divorce me, I won't demand the marriage gift. So give me the divorce, and you get away free. And that is used. In other words, that becomes a basis for her initiating divorce. Because part of what I really haven't talked about here at all, though it's an interesting question, is to what extent can she initiate divorce?
So this is my question. This is a rule given by very famous Shiite authorities, but it has never been practiced.
Oh no, it is used. It's used all the time. It's used a lot. There's the cold divorce,
Yes.
in which she essentially gives him. She says, "I don't want money," and 2/3 of divorces in Tehran are cold divorces at this point. So in practice, it's very widespread. This is her way of getting a divorce by saying, "I give up the marriage gift." So my point is that it's leveraged in a variety of ways. The marriage gift is not only leveraged to stop him from getting a divorce, it's also leveraged for her to get the divorce if she wants it.
So this is really in practice.
In practice, it's used a lot. It's very common. And it's interesting, actually, that's one of the reforms that's been added to the marriage code in Egypt. And I think they've adapted it from Iran, because it's been widely used in Iran. I mean, one of the things that happened in Iran was what they called the crisis of marriage, which was that there started being a lot more divorces post the revolution. And it went both ways, both women and men. So it's become more common for women to get a divorce themselves. I think to a large extent because many more women are capable of supporting themselves. And it's the same thing that happened in the United States as when more women started working. The divorce rate went up like crazy. But there were I guess across the world there are a lot of women who are kept in marriages simply by the mere fact of being supported. Once they're self-supporting, that reason disappears and the marriage dissolves. Sure. Yeah, all the way back.
So this, actually my question is regarding the same,
Yeah.
same
Yeah.
subject. So this is an agreement in front of the judge that you, as a woman, that you divorce me if I don't demand the money. Right? Is it something like that? Not necessarily.
Well, it could be. It could be.
Can just not divorce her.
It could be. The cold divorce is the agreement of that nature. There may be a bunch of divorces where that same thing's happening, but it's done privately, and he just simply renounces her, but the money doesn't have to go back. But as far as the record that kept the cold divorces, where the judge ratifies the idea that she gets out of the marriage and waives her marriage. Yes, sir.